The first case that we will hear oral arguments on is case number 18CA011252, State of Ohio versus Ziyad Hirbawi. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you're going to reserve time, let me know and I'll keep track of that for you and interrupt you when you get close to your rebuttal time. Oral arguments are recorded, so we do use the front podium. Please try to stay at the podium, keep your voice up so we can get a good recording for our YouTube channel. If there are children involved in the case, we ask that you refrain from using children's names or victims' names and use initials instead. Having said that, the panel has read the briefs and we are ready to proceed if you are.
Good morning, Your Honors. May it please the Court. My name is Ian Crawford. I'm one of the attorneys representing the appellant in this matter, Ziyad Hirbawi. I'd like to reserve 3 minutes for rebuttal.
Thank you.
Your Honors, this case presents two issues for appeal. One is a manifest weight argument. The other is sufficiency of the evidence argument. But the key to this whole appeal is whether my client, Ziyad Hirbawi, had knowledge that the drug that he had possessed and sold at his convenience store was an illegal substance. So this takes us back to June of 2015. Mr. Hirbawi ran and was the owner of a convenience store. It was called 611 Market. Sold a variety of different convenience store-like things, one of which was substance called spice. Now it's important to recognize that there are legal and illegal forms of spice. During this time, Mr. Hirbawi believed that what he was selling was of the legal variety. And in June of 2015, the Lorain Police Department were investigating Mr. Hirbawi's store for potentially purchasing stolen goods. It had nothing to really even do with this spice issue. They executed a search warrant to search the premises, ended up finding this vegetable, green-like plant matter, which ended up being spice. They asked Mr. Hirbawi about it. He said, "Oh, this is legal stuff. I sell it." He took them and showed them, where he stores it. It was found underneath a deli counter that he had in the back of his store. So the police officers noted that Mr. Hirbawi was compliant with them, with everything, but they couldn't tell by just looking at the substance whether it was legal or not. So they had to confiscate it, took it back for testing. They said, "Mr. Hirbawi, if you have any other issues or any other questions about the stuff that you're selling, let us know and we'll kind of help you out." About a month later, the Elyria Police Department was conducting an investigation into the 611 Market, and they were suspecting of the illegal variety of spice. They sent in a
Due to overdoses.
Due to overdoses
that were
occurring. Yes, that were occurring. Yes. And so they sent in a confidential informant through the Elyria Police Department, conducted a controlled buy, and obtained 2 packets of spice. Both the Elyria Police Department as well as Lorain Police Department sent what they confiscated to the Lorain County Crime Lab. Ended up coming back, testing positive as a controlled substance. Mr. Hirbawi was indicted, went to a bench trial, and was ultimately convicted of trafficking and possession. So, as I said earlier, the key to this is looking to see whether Mr. Hirbawi had knowledge that this spice was of the legal variety.
Isn't it complicated because I understand there were packages of spice that may have been indicating that it was legal.
Correct.
But he combined it with he didn't sell the package material, he combined it with some other substances that he mixed with it.
Well, what he did was he took the packages which said 100% cannabinoid free, DEA compliant, had websites, waivers on them, and he would take those and instead of selling the whole package to customers, he was trying to kind of stretch, make a little bit more of a profit off of them, and would take the substances out and would, weigh them to, fit what he thought was, what
Is
it
there
said
any evidence
for
that he mixed
$20.
anything extra into the product that?
There isn't anything, there isn't any evidence that says that, that he himself mixed anything. I'm sure the state's probably going to disagree with that, but there's nothing on the record outside of the fact that what he was selling was illegal. I don't think that's a question. It's more or less his knowledge of whether it was illegal or not. So one of the a big reason here is you can't tell by looking at it, and the state has admitted that in its brief. The state's witnesses, the detectives from the Lorain Police Department as well as the Elyria Police Department said, we can't tell just by looking at this whether it's illegal or not. Another factor that plays into it is the manufacturer packaging, where he would get it from. He would buy it from a wholesaler, packaging that it would come in, again, said DEA compliant, 100% cannabinoid free. It had a waiver, it had a website, and there's testimony from, I believe, the Elyria the Elyria Detective Straub, that said that he's never seen something, with the waiver, with the website where you could buy it that would be, illegal as far as spice is concerned. The other issue too is that the wholesaler that he would get it from was telling Mr. Hirbawi, hey, this stuff is completely legal. In fact, there was one instance where Mr. Hirbawi, while he was at the store, the wholesaler came to him and said, hey, this inventory that I gave you is illegal stuff. I need to take all of this inventory from you to get it out of your store. Here's some more legal spice. So he believed everything that this wholesaler was telling him. He had no reason not to. He had, there were instances where, if the wholesaler thought it was illegal, he would take it from him. So he believed what he was selling was legal. And another thing too is that during the Lorain Police Department's execution of the search warrant, they were, like I said, looking into initially stolen property. When Mr. Hirbawi, when they first started talking to him, Mr. Hirbawi said, "What stolen property?" He was kind of playing a little coy and eventually said, "Oh, you got me," something to that effect. When they started asking him about the spice, he was very upfront with them. Hey, this stuff is legal. Here's where all of my stuff is, and was very compliant with that. There was nothing suggesting him trying to hide this, from the police officers during this time. Now, obviously, the state feels a different way. They've cited to a case that this court decided in 2015, State versus Jackson, which has somewhat of a similar issue as far as the defendants there were charged with trafficking as well as possession, and they ultimately claimed in part, hey, we didn't have knowledge that what we were selling was illegal. But there are many facts that this court analyzed in that case that are not apparent here, that are simply not here. One of which, in Jackson, this court focused on the fact that the containers that the illegal substance, I believe it was Joy, was sold in was kept in the back in this container, and it had marked on the top of it, not for human consumption. And this court believed that harkened back to some statutory language regarding controlled substance, analogs of controlled substances, in Revised Code 3709.013. In this case here, there was no labeling of anything like that on any of his inventory, of Mr. Hirbawi's inventory. As I said, it was 100% cannabinoid free, DEA compliant. This court also focused in Jackson on the substantial markup that the defendants there were selling the Joy at. It was nearly a 350% profit margin that they were making on their sales. Here, Mr. Hirbawi was making $10 off of his sales. I wouldn't consider that. It was selling from $8 to $10 and was selling for $20. Finally, this court in Jackson noted that there was an enormous amount of demand for this, that there were people there was lines and crowds waiting outside this store wanting to buy this. There was testimony of someone driving 50 miles one way just to get to the store to buy this. There's none of that that's apparent here. So I think that the state's reliance on Jackson, while it has a similar general issue, is somewhat misplaced due to the factual nature and differences between the two cases. A couple other things that the state has tried to say, well, you know, Mr. Hirbawi was selling this and you had to ask for it by name, or it had to be a hand-to-hand transaction. Well, this is obviously the case because Mr. Hirbawi was holding this behind the counter. It's no different than any kind of cigarettes or e-cigarettes or any other kind of tobacco products. Of course, if you go to buy a carton of cigarettes, you're going to have to ask for the product. You have to ask for it by name, and it's going to have to be a hand-to-hand transaction.
Were these packages visible behind the counter like cigarettes would be?
They were not. They were kept underneath glass counter, but that wasn't the only thing that Mr. Hirbawi kept under the counter. He also kept e-cigarettes. His biggest issue was that he didn't want to put it out in the general public area because he was afraid it was going to get stolen. Because it did have some potential to look like, hey, this could be something that someone would look to steal.
Counsel, is there any evidence? I know that the box with the money included the spice proceeds, but did it include the e-cigarette proceeds as well?
Well, and that's to somewhat degree misleading. There wasn't any evidence that said this was 100% coming from the spice. Mr. Hirbawi was selling this spice for a $20 packet. This was what happened at the controlled buy. This is what he testified to. This is what the officer from the Lorain Police Department testified to. However, in the cigar box where the money was found, there's $133 left in there. And I'm no math wizard by any means, but 133 is not divisible by 20. So there was obviously some other kind of money that was getting put in and out of this, and it wasn't, just for the $20 for the bag of spice that Mr. Hirbawi would sell.
So in answer to the question, then, it probably isn't in the record one way or the other. Nobody specifically addressed whether e-cigarette money was put in the cigar box.
No, there was, to answer your question, no.
Thank you.
The state also tries to argue.
Counsel, you're right at about 3 minutes, just so you know.
Okay,
You want to reserve that?
I'll reserve that time. Thank you.
Thank you. Good morning, you'll have 15 minutes on behalf of the state.
Morning. May it please the court, Assistant Prosecuting Attorney Daniela Bearden on behalf of the state of Ohio. In this appeal, the appellant has raised two issues for this court to consider. Obviously, it's the sufficiency argument and then the manifest weight argument as to his convictions for trafficking in drugs and possession of drugs. So there were two cases that were consolidated for this trial that was heard before it was a bench trial. The issue primarily that the appellant takes is the knowing element for possession and for trafficking in drugs. It's agreed that this was a controlled substance, that the defendant was in possession of it, and that he was selling it. In viewing the evidence, so to address the first argument, the sufficiency argument, in viewing the evidence in light most favorable to the state, the trier of fact was absolutely able to conclude that the appellant knowingly possessed and trafficked in a controlled substance. To prove knowingly, the state is not required to prove that the defendant knew the specific characteristics of the items that he possessed and trafficked. Instead, the state must prove that the defendant knew or was aware of the probability of the item in his possession was a controlled substance. So in looking at the evidence that was presented for the first case, as counsel said, in 2015, the Lorain Police began investigating the 611 market, which was the appellant's market, because they were buying and selling stolen property. There were approximately 4 to 5 controlled sales during that time, and ultimately Lorain Police obtained and executed a search warrant. During the execution of that search warrant, it was determined that the 611 Market was a room where customers could come in and shop. It had a counter with a register. Behind the register, there was merchandise. And there was also an unused deli counter on the other side. So during the search, it was learned that underneath this unused deli counter, in the bottom, in a cubby hole, there was an old cigar box that contained cash. And then next to it was a large bag of a green, leafy vegetable matter.
So if I walked into that store and looked opposite from the counter with the register, I'd see this deli,
You would see the deli.
and nothing else.
Nothing else.
Like an abandoned, unused deli counter.
Absolutely.
No
There was no
signage,
needs,
no
nothing.
product, nothing.
Correct. That's my understanding from the record, Your Honor. So in finding that, the detective testified that he was suspicious that this was illegal synthetic marijuana or spice. And so one thing I do want to point out, so there's a lot of talk of this legal versus illegal spice. Well, spice is only legal because the manufacturers continue to change the compounds, and they're ahead of the legislative. And so once the legislative finds out the compounds, then they update the laws to reflect that it's illegal. So it's not a matter of their spice that's legal, it's just they're ahead of the legislation as far as changing the compounds to the drugs. As the appellant's counsel points out, that yes, in looking at the matter, the officers did testify. The lab technician did testify that you can't tell if it's a legal or illegal version. But again, that's not the standard of what the state has to prove. It's whether the defendant knew or was aware of the probability that the item was a controlled substance. And so in looking at the situation and looking that this was an item kept under the counter in a cubbyhole with cash separate from the register, it's apparent that the appellant knew that this was an illegal matter. In addition to what was found in under the deli counter, there was packaging found in the back of where he had emptied out all of the substance and put it into the large bag. So there was also a bag of the merchandise packaging that he kept separate, and there were garbage cans, but yet it appeared to the detectives that he was attempting to hide these. There was also a bag found that contained several smaller Ziploc plastic baggies, which indicated to the detective that the defendant, the appellant, was packaging these up into smaller packages to sell them.
He would concede that, wouldn't he?
Yes, he did, absolutely. One question that was asked as to whether or not the appellant was combining it with any other matters, and I believe that there was testimony that the appellant was mixing it with oregano. There was also an indication that he was possibly using acetone because there was a bottle of acetone found, and there was testimony that that is something that can be used to spray on the green leafy matter to make it a spice or the synthetic marijuana.
Are there legitimate uses for acetone?
Yes, there are, Your Honor. So in this initial search warrant, the appellant was asked about the synthetic marijuana. He indicated, I buy it from a guy, whenever I need it, he comes and buys it, or he comes and sells it to me. The detective said, hey, can you show me a bill of sale? Can you show me a receipt? Anything that shows that you're making these legitimate purchases. Appellant was never able to do so. In the second case, so now we're talking search warrants executed in June. Appellant's stash of synthetic marijuana is confiscated. He's aware it's being taken to the lab because there's a question of whether or not it's legal. The Elyria police become aware that the 611 Market is selling the synthetic marijuana because there were several overdoses, many of them were children, due to the synthetic marijuana. These kids were suffering from psychotic episodes and delusional behaviors. They were vomiting, having seizures. And so once it was determined that the appellant's store was possibly one of the sources for the synthetic marijuana, the Elyria police began to investigate. And through that, they arranged a control buy. So on July 9, 2015, a control buy was executed. The confidential informant went in and purchased a soda, a pop, whatever. So during that, the appellant was present. Appellant talks to the confidential informant, says, oh, hey, haven't seen you in a while. And the CI asks the appellant for 2 of them. The appellant goes in the back, gets 2 of them, and then instead of conducting a transaction at the register, they do a very discreet hand-to-hand transaction where the appellant gives him 2 packs of the synthetic marijuana, and the CI gives him $20 in cash. The confidential informant provided the Elyria police with 2 packs of Flight Risk Space Cadet synthetic marijuana. When the packaging was received, it appeared that it had already been tampered with and opened with, again indicating that the appellant was cutting the product in order to further his profit. The subsequent search warrant was executed by Elyria police. Again, underneath the counter, out of the view of the public, small baggies of marijuana, of the synthetic marijuana were found inside of the cigar box, out of the sight of consumers. Additionally, found in the back room was a digital scale. There was an empty safe, and in the ceiling, a 2-gallon bag of this green leafy matter was found, indicating defendant knew that this was illegal. Now he's making attempts to hide it. He's putting it in the ceiling. Again, he was talked to by the police. He admitted to he admitted to selling the synthetic marijuana, and similarly to the appellants in Jackson. In looking at the situation in that case, Jackson, they were selling bath salts. They claimed that they believed it was illegal. They were selling it out of the bath, so it was out of the sight of the customers. Customers had to come in, ask for it by name. In Jackson, they had a button on the register where they pushed joy, but it would come up as a t-shirt sale. I would say in this case it's a little bit more egregious because these transactions were not even occurring on the cash register. These were kept completely separate in the cigar box, and were not processed through the register. There was mention of the upsell of the product, so Enjoy, I believe there was testimony that it was $8 to $10 and being sold for $30-some. In this case, again, $8 to $10 being purchased, upsell to $20, but yet in this case, the appellant is cutting the product. So I think there's a little bit difference, or I think it shows that he was also trying to stretch his profit and to make the product go further. So I would argue that there was sufficient evidence presented for the trial court to find that the appellant knowingly possessed and trafficked in a controlled substance. As to the manifest weight argument, on behalf of the state, as I already indicated, 2 officers did testify and the appellant testified. The appellant testified he didn't know that the synthetic marijuana was illegal and that he purchased it from a wholesaler. The trial court was able to observe the appellant when he testified, able to determine his credibility, and quite frankly, the trial court clearly found him to be incredible, and that the testimony of the officers was credible. Accordingly, the appellant's convictions were not against the manifest weight of the evidence, and thus the state requests that this court uphold the appellant's convictions.
After the first search warrant where they took some of the product and tested it, was the defendant made aware that, did it test positive for a controlled substance?
Yes, Your Honor, it did.
Was the defendant made aware of that before the second?
I don't believe that the product had been tested by the time the second search had been done.
So all he knew was that it was confiscated during the first search warrant, but he did not know the results of the test.
I would say, Your Honor, I believe that he was aware of the probability that the item was illegal, that the substance was illegal. I mean, the police just came and confiscated all of your product and told you that they believe it's illegal, and yet he continued to sell in it despite knowing this.
The record's going to show that the police told them that they thought it was illegal.
I believe so. Well, I think that I don't know if it specifically says that the officer said, I told him I believe it's illegal, but I think that you can conclude from the facts and the testimony presented, if the police confiscated it to have it submitted for testing, they clearly believe that it's an illegal product.
Or maybe.
Correct.
Okay, thank you. Any other questions? Thank you very much.
Thank you.
Council, you'll have 3 minutes.
Thank you. Your Honor, just to clarify, from what the police told Mr. Hirbawi, the police told Mr. Hirbawi that they couldn't tell him to stop selling it because they weren't sure. There's a difference between whether they had probable cause to seize it based on the search warrant, as opposed to whether he wasn't arrested, so they didn't even have enough probable cause to make a formal arrest of him. The state has tried to develop several arguments here. One is that the manufacturer packaging was kept in the back even though there was a trash can. And apparently that, to them, makes it seem that they were trying to, that Mr. Hirbawi was trying to hide this from them. And I would argue that if he was really trying to hide it from him, wouldn't it make more sense to throw it in the trash can and get it out of the store if he was really concerned about someone seeing this? I don't think that necessarily has any legitimate weight as to that he was trying to hide the fact that he was selling this product. And I also don't think that the fact that he was trying to stretch a profit doesn't go towards whether he knew or whether he didn't know whether the product was legal or not. I mean, there's plenty of businesses throughout the world that you're trying and make profits in any way possible. Mr. Hirbawi thought that this was a way that he could try and make a profit.
Do you agree that he didn't have to have actual knowledge? If he was merely aware of the probability that it was a controlled substance, that's sufficient?
That is what the case law says. I would argue that he didn't know that he didn't think that it was. I would argue that Mr. Hirbawi believed what he was selling was legal. The fact that it potentially could have been illegal, I don't think necessarily is enough to convict him of possession and trafficking here.
What about the fact that he kept the bag, like a gallon of it in a ceiling tire?
I think a lot of it goes to the fact that Mr. Hirbawi was concerned about theft. This is, to the naked eye, it looks like it's some type of marijuana, and there's certainly crime, especially in convenience stores, robberies, thefts, that sort of nature. So if someone were to, break in and get into the back, and if it was just sitting out there, that would be an easy target to grab, as opposed to, trying to, put it in the ceiling.
Were there other items up in the ceiling too? For instance, the e-cigarettes?
To my knowledge, I don't believe that there was. I don't necessarily think that Mr. Hirbawi kept his inventory of e-cigarettes as much inventory of e-cigarettes as he did with this spice.
Council, with that, your time is up. Thank you.
Thank you, Your Honor.
Thank you, both of you, for your arguments this morning. The court will take the matter under advisement and issue a decision in due course. The clerk of courts will mail a copy of the decision on the day it is released to council, and the opinions are also posted on the Supreme Court of Ohio's websites, so you can keep an eye out there as well. I want to